Chapter 35 of Crime, Its Cause and Treatment by Clarence Darrow. This LibriVox recording is in the public domain. Recording by Peter Yearsley. Pardons and Paroles. It has always been the province of the chief executive of a state or nation to grant pardons or clemency to those who are confined in prison. This is largely to correct the mistakes of courts and juries, and is often indulged in by presidents and governors at Christmas time. Experience shows that during the trial of a case, especially one that causes public notice and general discussion, injustice is frequently done. Often the defendant is convicted when he should have been acquitted, and still more frequently punishments are excessive and cruel. Almost never is any serious inquiry made as to the heredity and environment of the accused. Probably, trial by jury has served to save many defendants where the judge would have convicted, and has still more often tempered and modified penalties. Still, juries are by no means free from the mob psychology that surrounds and affects most important and well-known cases. Jurors are generally none too intelligent, and not very ready to stand against public opinion. Most men agree with the crowd. The prevailing religious opinion and the dominant political and social ideas are accepted and believed by the ordinary citizen. Social and business considerations cause most men to go with the crowd, and in any case of importance, it is easy for a jury to tell the feeling of the populace. If the case has attracted much attention, the juror knows the prevailing ideas as to the guilt or innocence of the defendant. When he takes his seat in the box, he almost always shares that feeling. If the case is not one he has heard of or discussed, he can easily tell by the actions and surroundings of the courtroom how public feeling lies. All lawyers know how readily men feel the sentiment of a courtroom, and how much easier is the task when the sentiment is their way. Juries are also apt to have an undue regard for the opinion of the judge. In spite of the fact that it is their province to pass upon the facts, they are very watchful of all the judge says and does, and are prone to decide a case as they believe the judge wishes it to be decided. Even when the judge is not permitted to express any opinion on the facts involved, it is difficult for him to hide his real feelings, and when his desire is strong for either side, it is easy to make his opinions known. A jury is more apt to be unbiased and independent than a court, but they very seldom stand up against strong public clamour. Judges naturally believe the defendant is guilty. They feel that the fact that an indictment has been found is a strong presumption against the accused. The judge regards himself as a part of the administration of justice, and feels that it is a part of his duty to see that no guilty man escapes. Generally, in the administration of the court, he is very closely connected with the state's attorney, and naturally believes that the attorney would not have procured an indictment, much less pushed a trial, unless the defendant was guilty. The whole atmosphere of the court at the time of the trial calls for a harsher and more drastic dealing with the defendant than would naturally prevail after the feeling has passed away. For this reason, the pardoning power is given to the chief executive to correct errors or undue harshness after the legal proceedings have been finished. Often, after months or years, the persons or family who have suffered at the hands of the defendant feel like reversing their judgment or extending charity, and it is not unusual that the prosecutor and judge who conducted the case ask for leniency, and a mitigation of the sentence is imposed. So often is an appeal made, and so frequently is it felt just to grant clemency, that this part of the duty of the chief executive has grown to be very burdensome and really impossible for him thoroughly to perform. The policy of the law is further to give a prisoner some consideration, and in cases of good behaviour and mitigating circumstances, to release him before the expiration of his time. In most states, this has called for the creating of a board of pardons and parole. The statutes fixing penalties for certain offences provide for a reduction of a certain number of weeks or months each year, but as a rule, courts take this provision into consideration and figure out the net time they wish to give the defendant, so that there is no clemency except through pardon or parole. In most states, the duties of the board are very grave and its business large. With this has generally gone a law providing for the release of prisoners on parole before their sentences are finished. In these cases, the prisoner is paroled to someone who promises the board to employ him, and a monthly report is to be made of his conduct for a stated length of time. He is then given conditional freedom, subject to the revocation of the parole by the board on the violation of its terms. The administration of this power has made the parole board one of the most important, if not the most important, of any branch of the state government. The lives and well-being of thousands of prisoners are absolutely dependent on this board. Even more important are the happiness and well-being of the families of the inmates of the prison. The power and responsibilities of this board are so great that only men of the best judgment and of humane and just tendencies should be trusted with the task. It also calls for great courage, such as few men on boards possess. The public generally clamours for vengeance, and unfairly and unjustly criticises the board, especially when a released man violates his parole or commits another crime. This frequently happens. Perhaps, on an average, 10% of those paroled are sent back to prison before their term expires. All this makes it hard for the board to perform its duties, and makes the members of the board timid and doubtful of the result, often causing them to deny paroles in many cases where they should be given. A great deal of criticism has been made of the parole system. Public officials and that part of the crowd that is clamorous for vengeance are always ready to assail its activities unfairly and unduly. Most professional criminals are against the parole board. Speaking of the state of Illinois, I am sure that the parole law, instead of shortening the time of imprisonment, has lengthened the terms. All lawyers in any way competent to handle the defense of a criminal case would, in the event of conviction, almost always get a shorter term for their clients from a jury or from the court, or even from the prosecutor, than from the parole board. I feel strongly that the board is too timid and unwilling to grant paroles. Still, in spite of this, there can be no doubt that the parole law is a step in the right direction, and it should be upheld by all who believe offenders should have a better chance. If human nature in the administration of law could be relied on, if there were some method of getting men of courage and capacity, with plenty of competent aid and assistance, to take charge of paroles and prisons, then the ideal sentence should be one that fixed no time whatever. It should simply leave a prisoner for study and observation until it was thought wise and safe to release him from restraint. This, like all the rest, could not be done with the present public attitude toward criminals. So long as men subscribed to the prevailing idea of crime and punishment, no officials could stand up against public opinion in the carrying out of a new and radical theory, and even if such a board should be established, the law under which it acted would soon be repealed, or the members of the board forced to resign, and a new one would take its place. In spite of the fact that the effect of parole boards has been to lengthen sentences, and in spite of my personal belief that they should be materially shortened, I am confident that the parole system should be maintained, with the hope of improvement and the chance of gradually educating the public until sentences can be naturally shortened, and the care and control of prisoners be placed on a scientific and humane basis. A board of pardons and paroles should be made up of men who are really interested in their work. They should carefully keep up with the literature on crime and punishment. They should be scientists in all matters touching their work, and they should be men of humane feelings. It is too much to expect that all of this can be found in a board for a long time to come. But with good sense and the right attitude of mind, the board could employ the skill that it does not now have. Every prisoner should be the subject of attention, not of spying, but of friendly interest that would inspire confidence and trust, such an interest as a wise doctor has in a patient. This attention would, in most cases, gain the confidence of the prisoner and make it possible to find out how far he could be trusted, at the same time showing the treatment and environment he needed for future development. Where this confidence could not be had, safety would probably require a longer term. Most men respond to kind treatment. The criminal has so long looked on the world as his enemy, especially the official world, that he hesitates to trust anyone. Still, the really sympathetic and kindly man who is honestly trying to help him will, sooner or later, get his confidence and cooperation. Every prisoner should understand that all of those around him are anxious to educate him so as to fit him for society, and to put him in an environment where he can live. Even then there would be mistakes, and a portion of the prisoners would be so defective or imperfect that they never could be released, but under proper treatment many would be restored to association with their fellow men. It will be a long time before it will be safe to make sentences entirely indeterminate. Boards cannot be trusted to give such time and work and judgment to their task as will prevent cases of great injustice. Until such time shall come, either the statutes must fix an unbending and arbitrary time, which takes no account of individual cases, or it must be left with the court or jury. Clearly, the jury should fix the maximum, leaving the members of the board to reduce the penalty if they deem it wise. Most men are forgotten when they go to prison, especially if they have no active friends on the outside. No board can fully keep in mind all the inmates of a large prison. It may be that by some system their attention is automatically called to the man at certain times, but this matters very little. Someone should know he is there and why, and who he is. He should not be an abstract, but a concrete man. For these reasons, a limit should always be set on a punishment, and the limit should not be too long. The idea of a tribunal, perhaps including the judge who passed sentence, having the power and the duty imposed upon him to review sentences and reduce them if it seemed best from time to time, might have a good effect. The feelings of most men in reference to the degree of punishment change as time goes by. Always with the punishment is a strong feeling of both hate and fear. It is not possible really to punish, that is, to inflict suffering without hate or fear. The most necessary thing in preparing soldiers to fight is to teach them to hate and fear the enemy. In the trial of a case, these feelings are fresh in the minds of the prosecutor and the judge when the case is finished, and they necessarily act more or less under the dominance of their passions. In time, these feelings fade, and a saner and kindlier judgment takes the place of the first feelings that possessed the mind. With the parole system is going on a movement for probation. This provides that the convicted man need not be sent to prison, but may be released on certain terms, sometimes requiring that money taken shall be refunded. After that, he shall be placed under the supervision of some friend or agent, who will report from time to time to probation officers or to the court. Probation is generally granted to young prisoners and first offenders, but usually not permitted in cases that the law classifies as the most serious. Parole and probation are much the same in theory. In both these cases, the clemency should depend much more upon the man than on the crime. It does not follow that a very serious crime shows a poorer moral fibre than a lesser one. It may well be that the seemingly slight transgressions, like stealing small amounts, picking pockets, and the like, show a really weaker nature than goes with a more heroic crime. There is no such liability to repeat in homicide as there is in forgery, pocket-picking, or swindling. The seriousness of a homicide is likely to make it impossible that the same man shall ever kill again. Many such men would be perfectly safe on probation or parole. But the smaller things that are easily concealed and come from an effort of the condemned to live, either without work or in a better way than his ability or training permits him to do, in the hard and unfair conditions that society imposes, are often much harder to overcome. At any rate, the main question should be in regard to the man and not the crime. In cases of parole or probation, society should do what it can to help the man make good. Generally, employment is necessary, and a different and easier environment often indispensable. If organized society would only take the pains to make an easier environment for all the less favored, the problem would be fairly simple, and most of the misery that comes from crime and prison would gradually disappear. End of chapter 35. Chapter 36. Of Crime, Its Cause and Treatment, by Clarence Darrow. This LibriVox recording is in the public domain. Recording by Peter Yearsley. Remedies. Students of crime and punishment have never differed seriously in their conclusions. All investigations have arrived at the result that crime is due to causes, that man is either not morally responsible or responsible only to a slight degree. All have doubted the efficacy of punishment, and practically no one has accepted the common ideas that prevail as to crime, its nature, its treatment, and the proper and efficient way of protecting society from the criminal. The real question of importance is, what shall be done? Can crime be cured? If not, can it be wiped out, and how? What rights have the public? What rights has the criminal? What obligations does the public owe the criminal? What duties does each citizen owe society? It must be confessed that all these questions are more easily asked than answered. Perhaps none of them can be satisfactorily answered. It is a common obsession that every evil must have a remedy, that if it cannot be cured today, it can be tomorrow, that man is a creature of infinite possibilities, and all that is needed is time and patience. Given these, a perfect world will eventuate. I am convinced that man is not a creature of infinite possibilities. I am by no means sure that he has not run his race and reached, if not passed, the zenith of his power. I have no idea that every evil can be cured, that all troubles can be banished, that every maladjustment can be corrected, or that the millennium can be reached now and here, or any time or anywhere. I am not even convinced that the race can substantially improve. Perhaps here and there society can be made to run a little more smoothly. Perhaps some of the chief frictions incident to life may be avoided. Perhaps we can develop a little higher social order. Perhaps we may be rid of some of the cruelty incident to social organization. But how? To start with, it seems to me to be clear that there is really no such thing as crime, as the word is generally understood. Every activity of man should come under the head of behaviour. In studying crime, we are merely investigating a certain kind of human behaviour. Man acts in response to outside stimuli. How he acts depends on the nature, strength, and inherent character of the machine, and the habits, customs, inhibitions, and experiences that environment gives him. Man is in no sense the maker of himself, and has no more power than any other machine to escape the law of cause and effect. He does as he must. Therefore, there is no such thing as moral responsibility, in the sense in which this expression is ordinarily used. Punishment, as something inflicted for the purpose of giving pain, is cruelty and vengeance, and nothing else. Whatever should be done to the criminal, if we have humanity and imagination, we must feel sympathy for him, and consider his best good along with that of all the rest of the members of the society whose welfare is our concern. While punishment cannot be defended, still self-defense is inherent in both individuals and society, and without arguing its justification, No one can imagine a society that will not assert it and act for its defense. This will be true regardless of whether the given society is worth preserving or not. Inherent in all life and organization is the impulse of self-preservation. Those members of society who are sufficiently antisocial from the standpoint of the time and place will not be tolerated unduly to disturb the rest. These, in certain instances, will be destroyed or deprived of their power to harm. If society has a right attitude toward the subject, if it has imagination and sympathy and understanding, it will isolate these victims, not in anger, but in pity, solely for the protection of the whole. Some there are who ask what difference it makes whether it is called punishment or not. I think that the attitude of society toward the criminal makes the whole difference, and any improvement is out of the question until this attitude influences and controls the whole treatment of the question of crime and punishment. If doctors and scientists had been no wiser than lawyers, judges, legislatures, and the public, the world would still be punishing imbeciles, the insane, the inferior, and the sick, and treating human ailments with incantations, witchcraft, force, and magic. We should still be driving devils out of the sick and into the swine. Assuming then that man is governed by external conditions, that he inevitably reacts to certain stimuli, that he is affected by all the things that surround him, that his every act and manifestation is a result of law, what then must we and can we do with and for the criminal? First of all, we must abandon the idea of working his moral reformation, as the term moral reformation is popularly understood. As well might we cure the physically ill in that way. Man works according to his structure. He never does reform and cannot reform. As he grows older, his structure changes, and from increase of vitality or from decrease of vitality, his habits too may change. He may likewise learn by experience, and through the comparing and recalling of experiences and their consequences, may build up rules of conduct which will restrain him from doing certain things that he otherwise would do. Anything that increases his knowledge and adds to his experience will naturally affect his habits, and will either build up or tear down inhibitions, or do both, as the case may be. If he has intelligence, he knows he is always the same man, that he has not reformed nor repented. He may regret that he did certain things, but he knows why and how he did them, and why he will not repeat them if he can avoid it. The intrinsic character of the man cannot change, for the machine is the same, and will always be the same, except that it may run faster or slower with the passing years, or it may be influenced by the habits gained from experience and life. We must learn to appraise rightly the equipment of every child, and, as far as possible, of every adult, to the end that they may find an environment where they can live. It must never be forgotten that man is nothing but heredity and environment, and that the heredity cannot be changed, but the environment may be. In the past and present, the world has sought to adjust heredity to environment. The problem of the future, in dealing with crime, will be to adjust environment to heredity. To a large extent, this can be done in a wholesale way. Any improved social arrangement that will make it easier for the common man to live will necessarily save a large number from crime. Perhaps, if the social improvement should be great enough, it would prevent the vast majority of criminal acts. Life should be made easier for the great mass from which the criminal is ever coming. As far as experience and logic can prove anything, it is certain that every improvement in environment will lessen crime. Codes of law should be shortened and rendered simpler. It should not be expected that criminal codes will cover all human and social life. The old method of appealing to brute force and fear should gradually give place to teaching and persuading and fitting men for life. All prisons should be in the hands of experts, physicians, criminologists, biologists, and above all, the humane. Every prisoner should be made to feel that the state is interested in his good, as well as the good of the society from which he came. Sentences should be indeterminate, but the indeterminate sentence of today is often a menace to freedom and a means of great cruelty and wrong. The indeterminate sentence can only be of value in a well-equipped prison, where each man is under competent observation, as if he were ill in a hospital. And this should be supplemented with an honest, intelligent parole commission, fully equipped for thorough work. Until that time comes, the maximum penalty should be fixed by the jury, the parole board retaining the power to reduce the punishment or parole. No two crimes are alike. No two offenders are alike. Those who have no friends in the outside are forgotten and neglected after the prison doors have been closed upon them. Some men now are confined much too long, others not long enough. No doubt, owing to the imperfections of man, this will always be the case. At present, no penal institutions have the equipment or management to provide against such shortcomings. They never can have it, while men believe punishment is vengeance. When the public is ready to provide for the protection of society, and still to recognize and heed the impulses of humanity and mercy, it will abolish all fixed terms. As well might it send a patient to a hospital for a fixed time and then discharge him regardless of whether he is cured or not, as to confine a convict for a definite, predetermined time. If the offence is one of a serious nature that endangers the public, the prisoner should not be released until, by understanding or education or age or the proper form of treatment, it is fairly evident that he will not offend again. When the time comes, if it is the day of his incarceration, he should be released. The smallest reflection ought to teach that for many crimes, especially for many property crimes, it is hopeless to release a prisoner in an environment where he cannot survive. An environment adjusted to his heredity must be found by the state. All indignities should be taken away from prison life. Instead, the prisoner should be taught that his act was the necessary result of causes and effect, and that, given his heredity and environment, he could have done no other way. He should, by teaching and experience, be shown where he made his mistakes, and he should be given an environment where he can live consistently with the good of those around him. Various reforms have been urged in the treatment of criminals and in criminal procedure in the courts. Most of these impress me as possessing no fundamental value. It is often said that the accused should be given an immediate trial, that this and subsequent proceedings should not be hindered by delay, that the uncertainties of punishment furnish the criminal with the hope of escape, and therefore do not give the community the benefit of the terror that comes with the certainty of punishment that could prevent crime. I can see no basis in logic or experience for this suggestion. It is based on the theory that punishment is not only a deterrent to crime, but the main deterrent. It comes from the idea that the criminal is distinct from the rest of mankind, that vengeance should be sure and speedy, and that then crime would be prevented. If this were true, and the only consideration to prevent crime, then the old torture chamber and the ancient prison with all its hopelessness and horror should be restored. Logic, humanity, and experience would protest against this. If there is to be any permanent improvement in man, and any better social order, it must come mainly from the education and humanizing of man. I am quite certain that the more the question of crime and its treatment is studied, the less faith men have in punishment. England and continental Europe are often pointed to as examples of sure and speedy justice. The fact that there are more convictions and fewer acquittals in England in proportion to the number of trials does not prove that the English system is better than ours. It may, and probably does, mean that ours is better. Here the accused has more chance. There, the expense, the formality, the power of the court all conspire to destroy every opportunity of escape, regardless of innocence or guilt. Even the fact that there are fewer crimes committed in England does not prove that the system is best or that it prevents crime. An old country with its life of caste lacks the freedom and equality that naturally produce defiance of rules and customs and lead to breaches of the law. Other things being equal, a greater degree of freedom leads to more violation of rules and greater resisting power among the poor than a lesser degree of freedom. It does not necessarily follow that the country is best where the people are the most obedient. Complete obedience leads to submission, to aggression, and to despotism. Doubtless, China has fewer crimes than England. The power of resistance is so crushed that no one thinks of defying a master, resenting an injury, violating a rule, claiming any personal rights, or protesting against caste, age, or privilege. Always there are certain men who believe that all reform in criminal procedure must come by abolishing juries and submitting every question to a court. Those who are rich and strong, and the lawyers who advocate their interests, are mainly arrayed on this side. The poor and rebellious, with those who naturally or otherwise advocate their cause, stand for the juries as against the courts. Those who strive to be fair are often misled from a lack of experience and little judgment of human nature. The public is always against the accused. The press is against him. The machinery of the law is against him. The dice are loaded for his conviction. Some people have childish faith in the courts, but judges are neither infinitely wise nor infinitely good. They come from the ranks of lawyers, and for the most part from those who have been long engaged in defending property rights. They are generally conservative. They are not independent of public opinion. Almost invariably, they reflect public opinion, which means the public opinion of the community in which they live. Few of them have much knowledge of biology, of psychology, of sociology, or even of history. One curse of our political life comes from the fact that as soon as a man has secured an office, he has his eye on another, and his whole effort is to please the people, that is, the people who express themselves the most easily. Very few judges rise to a great degree of independence or defy popular clamour. A jury is less bound by public opinion. Their responsibility is divided. They are not, as a rule, seeking office. While swayed by the crowd, they are still more independent than judges, and with them the common man, the accused, has a better chance. No doubt judges are abler, better educated, more accustomed to weighing evidence, and able to arrive at a more logical conclusion than most juries. Still, none of these qualities necessarily leads to just findings. Questions of right and wrong are not determined by strict rules of logic. If public opinion could come to regard the criminal as it does the insane, the imbecile, or the ill, then a judicial determination would be the best. But as long as crime is regarded as moral delinquency, and punishment savours of vengeance, every possible safeguard and protection must be thrown around the accused. In the settling of opinions and the passing of judgments, mob psychology is all-powerful, and really, in the last analysis, every human question comes down to the power of public opinion. The first thing necessary to lessen crime and to relieve victims from the cruelty of moral judgments is a change of public opinion as to human responsibility. When scientific ideas on this important subject shall be generally accepted, all things that are possible will follow from it. Some headway has already been made in the direction of considering heredity and environment. Theoretically, we no longer hold the insane responsible, and some allowance is made for children and the obviously defective. The discouraging thing is that the public is fickle and changeable, and any temporary feeling overwhelms the patient efforts of years. In the present mad crusade against crime, consequent upon the Great War, penalties have been increased, new crimes created, and paroles and pardons have been made almost impossible. The public and press virtually declare that even insanity should not save the life of one who slays his fellow. Repeatedly, the insane are hanged without a chance, and sentences of death are pronounced where before a term of years or life imprisonment would have been the penalty for the offence. Individual men and collections of men are ruled not by judgment but by impulse. The voice of conscience and mercy is always very weak and drowned by the hoarse cry for vengeance. As long as men collectively impose their will upon the individual units, they should consider that this imposition calls for intelligence, kindliness, tolerance, and a large degree of sympathy and understanding. In considering the welfare of the public, the accused, his family, and his friends should be included as a part. It need not be expected that all maladjustments can ever be wiped out. Organization with its close relation of individual units implies conflict. Nevertheless, the effort should be to remove all possible inducement for the violent clashing of individuals, and to minimize the severity of such conflicts as are inevitable. The End of Crime, Its Cause and Treatment by Clarence Darrow.